Happy 4th of July. This is Maryann from Slam the Gavel podcast. Today I'm going to read you an article written by Michael Phillips, which you can find him on Substack, called What to the Parent is the 4th of July? So he writes, on America's 250th birthday, the oldest liberty the Supreme Court recognizes remains the least protected right in American law. Now, in 1852, Frederick Douglass stood before an audience in Rochester, New York, and asked a question nobody in the room wanted asked. What to the slave is the 4th of July? His answer was not to burn the founding documents. It was to read them aloud and to indict the country by its own charter and to insist that the promise of 1776 belonged to the people America had failed, or it belonged to no one. Now, Frederick Douglass is in quotes here. I prefer to be true to myself, even at the hazard of incorrigible people finding me such. So, 174 years later, on the nation's 250th birthday, that method still works. So let's use it. Let's read the Declaration of Independence the way a parent reads it after their first custody hearing. Okay, Michael writes, the grievances then and now. And most Americans remember the Declaration's opening lines. Fewer remember that the bulk of the document is a bill of particulars, 27 specific grievances against King George III, itemized like a complaint filed with a court that no longer existed for the colonists. Now, if you read a few of them today, he has in quotes, he has obstructed the American justice. Now, in the modern family court, it's justice delayed, access denied. Cases drag on for months or years. Motions stack up. Parents wait while their children grow up without court-ordered time they need and deserve. Now, the second one is, in quotes, he has made judges dependent on his will alone. Now, in modern family court, judicial discretion without accountability. And I'll add, like always, family court judges wield enormous power with little meaningful appellate review and no jury to check their decisions. Now, the next one Michael has is he has erected a multitude of new offices and sent hither swarms of officers to harass our people and eat out their substance. Okay, now, in modern family court, swarms of officers, guardian ad litems, custody evaluators, parenting coordinators, reunification therapists, supervised visitation providers, and more, appointed by the court, paid by the parties, protected by immunity. Hard to believe. The next one he has is for depriving us in many cases of the benefits of trial by jury. No jury, here we go, modern family court, no jury, lower standard, life-altering results. Parents can lose custody of their children on a preponderance of the evidence standard decided by a single official with no jury ever. So, Michael writes, now walk into the family court in America. A parent contesting custody today will encounter a multitude of offices the founders never imagined. As mentioned, these guardian ad litems, custody evaluators, parenting coordinators, reunification therapists, supervised visitation vendors, co-parenting class providers. These officers are appointed by the court and not chosen by the parties. The parties, not the state. So, and I'll add to that, if a parent is already paying for a therapist that they go to see, now they got another bill on top of that. Okay. Now, their recommendations carry dispositive weight with the judges, and in most jurisdictions, they enjoy wholeheartedly quasi-judicial immunity, meaning the parent who pays them cannot fire them, cannot meaningfully cross-examine their methodology in many courtrooms, and cannot sue them when they get it wrong. I'll add to that all the time. They get it wrong. Swarms of officers eating out their substance. The founders wrote the sentence 250 years ago. Family court built a business model. And the jury, the colonists demanded, it doesn't exist here. Family court is one of the only venues in American life where a citizen can lose the thing that Supreme Court calls fundamental liberty, the custody of their own children, on a preponderance of the evidence standard decided by a single official with no jury ever. A civil defendant fighting over a $5,000 contract dispute has a right to a jury. A parent fighting for their child does not. Boy, this is a great article that you can find on Substack written by Michael Phillips. So he talks about the oldest liberty, the weakest protection. This is not a fringe reading of the law. It is the Supreme Court's own framing. Now, in 1923, Mayer versus Nebraska, 262 U.S. 390. Now he's got 1925, Pierce versus Society of Sisters, 268 U.S. 510. 1982, Santosky versus Kramer, 455 U.S. 745. Year 2000, Troxel versus Granville, 350 U.S. 57. 2011, Turner versus Rogers, 564 U.S. 431. And he goes into all of those in his graph, okay? So he continues. In Troxel versus Granville, year 2000, the court described the interest of parents in their care, custody, and control of their children as perhaps the oldest of the fundamental liberty interests it recognizes. The lineage runs back a century. Meyer versus Nebraska, 1923. Pierce versus Society of Sisters, 1925. Santosky versus Kramer, 1982. The words are carved into constitutional doctrine. And I'll add to that, it's not followed. But compare the procedural armor around the oldest liberty to the armor around newer ones. Accused of a crime, you get counsel, a jury, proof beyond reasonable doubt. Facing a $500 fine, you get robust due process. Facing the loss of your children in a custody proceeding, you get a judge, a preponderance standard, and a huge, huge bill. Now, in Turner versus Rogers in 2011, the court held that a parent facing jail for civil contempt over unpaid child support has no categorical right to appointed counsel, even though the door of the cell closes just as firmly as it does in a criminal case. Parents in this country are incarcerated in civil proceedings without lawyers over debt generated substantially inside the system itself. Arrears. And I'll add to that, a judge can add $3,000 onto their arrears at whim, like my judge did. Good for her. Interest, evaluator fees, guardian ad litem invoices, attorney bills, accumulated fighting for time with their own children. The founders had a phrase for imprisonment over debt administered by unaccountable officers. Several of their grievances were about exactly that. And my graphed here. Okay, the oldest liberty, the weakest protection. And if you can go look at that on Substack, it's really, really very good. The incentive architecture. Father and Company does not traffic in conspiracy theories, and this piece will not either. You do not need a cabal to explain what the family court system does. You need only to follow the documented incentives because incentive architecture, unlike conspiracy, leaves receipts. Title 4D of the Social Security Act reimburses states for child support enforcement activity, which means collection infrastructure is federally subsidized while parenting time enforcement is not. Ever. The result is measurable asymmetry. A parent who misses a support payment faces wage garnishment, license suspension, passport denial, and jail. A parent whose court-ordered time with their child is withheld faces, in most jurisdictions, a motion, a filing fee, a months-long wait, and a judicial shrug, and I'll add to that, a bunch of continuances to drag the court case out. Now, Michael also writes, one violation has an enforcement apparatus, the other has a suggestion box. Court-appointed professionals bill hourly with rates set by the market and immunities set by the courts. The longer the case runs, the more it pays for everyone except the family. No individual actor needs bad intent for the system to produce the outcome it produces. The machine is simply built to run long, and families are the fuel. This is not an accusation, it is an accounting. And accounting was good enough for the men who itemized 27 grievances against King George III. So, one created rights, the family court, the other decides whether you see your child. Now, the Declaration signers pledged their lives, fortunes, and sacred honor for the proposition the legitimate power exists to secure rights, not to consume the people it governs. Measure modern child welfare system against that standard. Children are unalived in foster care under state supervision in cases that this publication and others have documented. Children are converted into leverage in custody litigation, instruments in war of attrition that the fee structures rewards. Parents with disabilities find those disabilities weaponized in evaluations. Poor parents lose children for conditions of poverty that a fraction of the litigation's cost could have remedied. Wow, let me read that one again. Poor parents lose custody for conditions of poverty that a fraction of that litigation's cost could have been remedied. Michael continues, every one of these failures is documented year after year. In-state audits, inspector general reports, and court files. The system knows, the reports are public. The country's 250th birthday, the question is not whether the evidence exists, it is whether anyone with power is obligated to read it. Frederick Douglass's answer? So, what to the parent is the 4th of July? Douglass gave the answer in 1852, and it holds the 4th of July belongs to the people, the system has failed. Precisely because the founding documents are the strongest indictment available against the system that failed them. The Declaration is not the property of the courts that ignore it. It is a standard that they will be measured against. A parent who has been through this system does not have to choose between loving the country and telling the truth about it. Telling the truth about it is the love, the demanding, documented, unsentimental kind the founders practiced when they put their grievances in writing and signed their names. The family court system was built to outlast the people inside it, to exhaust their money, their time, and their will. Some of us are still here anyway, or still standing, still writing, still holding the receipts. Now, in quotes, power concedes nothing without a demand. The documentation continues. So 250 years ago, a group of parents, most of the signers were fathers, all of them were sons, decided that when a system of unaccountable officers eats out the substance of the people, the remedy is to document every grievance and publish it to the world. Happy birthday, America. Here are the grievances. The documentation continues. Now, he shows America's birthday and the family court reality, one from 1776, the other from 2026. 250 years of liberty, one fundamental right is still waiting. So I totally thank you, Michael Phillips, for writing this article here on July 4th, 2026. And I really am glad we got to go over this. And everyone, please join me on Slam the Gavel. You can find me on YouTube. Please like, subscribe, and share, and help the public understand what really goes on in these courtrooms. Again, I'm your host, Maryann Petri. You can find me on Spotify, YouTube, Apple iTunes, iHeartRadio, and other platforms I don't know about. Again, feel free to buy me a coffee to help keep this podcast going. Thank you so very much. And I'll show you my fabulous t-shirt. Remember that? From Legally Blonde 2. Okay, so I hope you all have a great, safe 4th of July. Thank you.